and the National Organization, Labor and Employment Relations Association. Welcome to all of you. My name is David Jacobs. I'm the president of DC Lera, as well as a faculty member in business at American University. Just to give you the background, the Labor and Employment Relations Association is a nonpartisan national organization with professionals interested in labor issues from multiple perspectives, from the employer's labor side, from the academic side, activist side. We meet and share ideas about practice and even about theory. Hard to imagine that. So the Labor and Employment Relations Association was founded in 1947 as the Industrial Relations Research Association. So it's been around for quite a long time. We're the DC chapter. We have monthly webinars and much participation from national policymakers and labor attachés from around the world. And this whole event today is organized by our labor attachés from around the embassies. Petra Hansson from Sweden is a counselor with the Embassy of Sweden, serves on the DC Lera board along with other social policy types of the embassies. She'll moderate the session and introduce our European panel. Feel free to identify yourself in the chat. Hold your questions till the end, and then you can either answer you from the chat, or you can show up on screen, ask the question directly of our panelists. If you're not a member of DC Lera, you can log on to dclera.org and consider joining. Our upcoming sessions include Anton Hajar of the US Postal Service Board of Governors, who will be speaking on May 18th, moderated by Mindy Reiser. And then June 22nd, we will have Karen Nussbaum panel, actually a film, about 9 to 5. We also have a labor law seminar, which will be June 16th, the second annual labor law forum, chaired by Tila Brooks, who's on the panel with us today. So hello to everybody. Petra, the floor is yours.
Thank you, David. It's very exciting to be here, and thanks to everybody who's joining us. So today we have 3 panelists. Very excited about this. They're all joining us from Europe. So we have Roman Kormann joining us from Berlin. He's an advisor with the German Trade Union Confederation. We have Mijke Houwerzijl from the Tilburg University in Southern Netherlands. And we have Annamaria Westregård from Lund University in Sweden. And they are all 3 working on this topic that we are addressing today, which is the gig economy. So I'll just give a very brief introduction, and then we'll kick it off with the panelists. So the gig economy, of course, it has many names. A lot of time we call them platform workers. There's also the term of crowd working, which I've seen that the ILO uses. In Europe, they tend to say also non-standard workers. So there are many names for this phenomenon. And of course, it's all about the digital transition also being accelerated by the COVID-19 pandemic, which is shaping Europe's economy and its labor markets. So today, according to the European Commission in Brussels, over 28 million people in the European Union work through or do some work through digital labor platforms, but it's also expected to grow a lot. So the European Commission says that by 2025, the number is expected to reach 43 million. So we'll see about that. But it's just clear also that the pandemic has highlighted and reinforced inequalities of access to social protection in European labor markets. So what will this lead to is the question. In a part of the world where labor markets tend to be very regulated for the most part, and also access to healthcare and social benefits for workers tends to be generous for the most parts. And also these are societies, depending on which European country you're focusing on, but for the most part, unions have a strong role, and especially in Northern Europe, which we'll be looking at today. So we're going to hear, as I said, from 3 experts from Germany, Netherlands, and Sweden. All 3 countries are members of the European Union, and all 3 have a tradition and practice of strong unions and of structures for social dialogue, collective agreements in the labor market. But these structures are also quite different. It also depends if they are centralized covering the whole country, or decentralized. And also in tax law and rules when it comes to access to social benefits, these 3 countries also differ. And when you're looking at Europe, you're also wondering, okay, so what's the situation when it comes to European level, that is the Brussels level, with the legal framework for the whole union. So let's just note that there's a patchwork of minimum harmonization in labor law. So it's not part of the standard harmonized legislative European framework, but there are some common European labor standards that are there for all the countries. And of course, all European countries are bound by UN conventions, then the European Convention on Human Rights. And there is also such a thing as the European Pillar of Social Rights, which is kind of the foundation for the work that's being done right now, including for the gig economy and setting standards for Europe in that regard. And then on the other hand, you have EU competition law, which is also relevant to our discussion today. And that legislation is harmonized on the European level. And so the same rules apply to businesses in all member states. And so I mentioned the European Pillar of Social Rights that was adopted a couple of years ago. There's a recommendation in there that aims to implement the right to adequate social protection for all workers within Europe and under comparable situations, the self-employed, regardless of the type and duration of the employment relationship. So that's relevant for us today. And so what has happened very recently is that the European Commission at the end of last year proposed a directive on improving working conditions in platform work. So if it passes, it will require all 26 member states, or 27 rather, to change their regulation in relation to platforms. And it will introduce a two-step process for platforms to determine the employment status of workers and also the social protection and benefits that come with this status. It also will address algorithmic management, so the transparency and oversight of algorithms that platforms use. That's also part of the proposed directive. And also when it comes to data transparency and what they share with national authorities to give these authorities a better idea of what is going on. So we will go deeper with our panelists on how this legal proposal has been received on the national level in our three countries. So just let me quickly note that the pandemic also has triggered debates on the situation of specific categories of workers and on the need to address gaps in their protection, which is also, you could say, the case here in the United States, and also the active role that trade unions have. And there were temporary changes made to benefit schemes, unemployment benefits during the pandemic. And finally, we have had also a number of court cases in Europe, not just in these three that we're focusing on today, but also in others. And I hope our panel can tell us a bit more about those and what the situation is, driving new practice, new rules. Okay, so now I will introduce our speakers. Maybe just to note the difference in these countries when it comes to size. Germany has over 80 million people, the Netherlands about 17 million, I think, and Sweden, my own country, has 10 million people. So it's a big difference when it comes to scale. But geographically, they are close to each other, of course. And so now I would like to turn to Berlin and introduce Roman Kormann. You are an advisor with the German Trade Union Confederation. Thank you for joining us. I'm very curious to hear what the reactions are in Germany to the draft directive that the European Commission has put forward. Just to quickly note that you are also very much working on this topic in your everyday work. I understand you are part of a project called the Digital Worlds of Work and Workplace Reporting. That is the name of your department. And you have a project called the Work of the Future, where you are working on topics such as platform economy and artificial intelligence. And I understand also solidarity and work for participation. So please tell me a little bit about what's going on in Germany and how you feel about the proposals from Brussels. Thank you.
Yeah, thanks, Petra, and thanks for inviting me to this really important topic. I will just start my presentation so we have time after that to discuss what we just heard now. I hope all of you can see my presentation.
Yep, it's there.
Okay, now in the full mode. So thanks for inviting me. Before I start with the German perspective, I would first show you the European perspective. Petra, you just shortly introduced a bit the European perspective. And what I want to say is that platform work is not just on the edge, a phenomenon on the edge of the labor market. A lot of people in Europe are working in the platform economy, and for, I would say, nearly 5 to 6%, it's their main job or their secondary source of income. And I would say that's pretty much, and you already said it, with the COVID crisis, the number of people working in that field are rising. What I think is interesting is that the average age of people working the platform work in Europe is lower than in traditional businesses, and they're highly educated. And what I think is really important too is that the migration background is really high, and I would say that is an indicator that a lot of people with migration backgrounds are not really getting into the labor market, and that platform work is for them first step to get into the market, because the level to get in is really low in the platform work. In Germany, the number of people working in the platform economy is pretty much on that level as in Europe as a general. Around 5% are active crowd workers, and crowd workers, and this definition means platform workers in general, so in the gig economy, and crowd workers, of course. So there are other studies from the Commission, from the EU Commission, that says that around 6% in Germany get their around 25 to 50% of their income from the platform work. So it's pretty much high. The problem with the studies is that the research results are still very widely, and that has to do that the business models are really diverse, and of course the industry is highly dynamic. They're always getting more and more platforms out of the bottom. They're coming maybe every day new platforms, and it's really hard to get a picture on that. And on the other hand, it's hard to get a definition of platform work. You always already said it. There are terms like gig work, crowd work, platform work, and there are also own terms on different platforms like creators, gurus, creatives, and maybe YouTubers too. So it's really hard to get a closed concept on what is platform work, and that has a result on how to get a picture of the whole thing. When it comes to Germany, on the perspective on the relationship between dependent employment, self-employment, and their integration into social security systems, I have to say that in Germany, around 4 to 5% of the workforce are self-employed without employees, so-called solo self-employed, solo self-employees. What is rising in Germany is like hybrid forms of employment, where you have dependent employment on the one hand, and then there are maybe phases of self-employment or combined situations with dependent employment and self-employment, and that is pretty much a thing in the platform work too, where you have maybe a main job, and then you do like crowd working as a secondary or third income or whatever. And the developments are problematic because they're accompanied by gaps in protection under labor and social law. In Germany, social security with health insurance, pension insurance, long-term care insurance, and unemployment insurance is strongly orientated toward dependent employment, in which the employer and the employee usually make their contributions in equal shares and are thus protected. In addition, the basic right guarantees the social partners' freedom of association, collective bargaining autonomy, and the right to strike. And the rule of co-determination at the company level are filled by the Works Constitution Act. They represent like the operational rules of what is to be negotiated or can be negotiated between the Works Council and the company. And these protective frameworks are largely absent in the status of self-employment. Behind this is the outdated notion that self-employment workers are generally well enough off to provide for old age, illness, joblessness, and nurse care on their own. And that's pretty much a challenging situation when it comes to the platform economy, because the platforms are often said they are like intermediates. They're just connecting the client and the person who is working on the platform. And for us, that's pretty much not the thing, because the platforms are controlling often the people by monitoring them via the algorithm, and they are controlling them. But when it comes to like you want to go to a court and say, okay, I'm not a self-employed and I see myself as an employee, it's pretty hard to get through this black box of algorithms and to prove that that you get controlled by the algorithms. And there was, of course, a decision of the Federal Labor Court in 2020 that was pretty much good for us, because the court says that the crowd worker who was there to addressing the right status says, okay, you get a new form of digital directive through the algorithm, and there are situations like gamification modes you get controlled with, and you have to be an employee. That was a pretty much a good case for us. But I have to say that these decisions are case-by-case decisions, and you can't, you need a political, a broader basis to address these new forms of algorithm controls. The Commission just drafted a regulation on platform work, and I think that's the right first step for us. It addresses the right problems, like the status of employment, like the algorithmic management, like transparency. But for us as the trade union, it's important to get to the employees to organize the workers, and that also the draft is addressing. For us, it's really important to get transparency about the algorithmic control systems, how the algorithmic is working, and of course, at the end, have influence on the algorithmic management systems. At the end, we need like a reversal of burden of proof, because what I said, it's nearly impossible for the people to show that they're dependent workers. At the end, I just want to show you shortly what the trade unions in Germany are doing in terms of platform work. Our United Services Union are organizing self-employed people for some years now, and also in the platform work. Our industrial union is organizing for some years platform workers, and has especially crowd workers, so just the online workers. and they reached an agreement with, I think, 10 crowdworking platforms in Germany in the form of a code of conduct to ensure, for example, fair pay, and our union, Food, Beverage, and Catering Union, is organizing riders in the field of food delivery. So that's my part for a short, picture in Germany, and I hope there are some questions we can argue later.
Excellent. Thank you so much for that. Very interesting, very clear. And yes, I think there will be plenty to come back to in your presentation. So that was Germany, seen from the union side. Excellent. And I will now move to the Netherlands. And Mijke, Professor Mijke Houwerzijl, I hope I'm pronouncing that in a decent way. You are joining us, thank you. You're joining us from the south of Netherlands, somewhere close to Antwerp in Belgium, but not too far from Rotterdam as well. Is that correct? I had to check on the map. I'm sure it's a beautiful region south there.
It's
so
correct.
wonderful. It's wonderful to have you on. And you are a professor of labor law at Tilburg University. You're also a board member of the Institute for Labor Law and Industrial Relations in the European Union and more. You have published on legal aspects of labor mobility within the European Union, and also on cross-border subcontracting, the working poor, economically dependent workers, and platform work, among other things. So we're excited to hear from you about gig workers and their protection under Dutch labor law, and the reactions in the Netherlands to the proposal from Brussels on the gig economy. Thank you for joining us.
Okay, thank you, Petra, for the kind introduction and also for the invitation to the organization of this webinar. I will try to share my screen now. Let's see.
Yep, it's there.
It's there, right?
Yes.
So now I have to go to the beginning. Yes. Yes, so the situation in the Netherlands. You see here, well, some old figures, because this is from a study in 2016, and just to give you a little bit of contextual information to start with. Netherlands is indeed a small country, much smaller than Germany, 17 million inhabitants, as Petra already said, but we are also, perhaps it's good to know, a very digitalized country. It's a very small country. If you think of the territory, it's almost like a city-state, you could say, perhaps. Anyways, so in the Netherlands, in 2016, so that was quite at the beginning of what we then called the sharing economy, and now the platform economy. This was a bit the estimate. Perhaps you can read it. I think it's not so clear because it is based actually, and that's, I think, important when we talk about all these numbers, much more on trend reports and surveys than on real hard statistical empirical findings. So the basic message is not so much how much, that we really know how much people are involved in platform work or gig work or crowd work or however we should call it, but more that it is an upward trend, and that is quite clear also in the Netherlands. So here is what I just tried to say. It's all based on interviews of people themselves. And in the beginning, it was quite clear that in the region where I am, so Tilburg, that there were not so much people, for instance, who knew about Uber drivers at that time than in the big cities like in Amsterdam. So it's also unevenly spread, actually. What is also perhaps interesting for you to know is that we are aware in the Netherlands of the difference between platform work on location. So it's actually traditional work, but it's intermediated by an online platform like meal delivery and the Uber drivers. But you also have this crowd work, as we see it, tend to interpret it like that the work mediated by the platform is also online. As you have, I think in America, the Amazon Mechanical Turk as the example. That also seems to be going on in the Netherlands and widely also in Europe, but we at this time do not have so much debate about that part, and also it's very difficult to get knowledge about what is going on there because it's very covert. Here you see a starting point which might be interesting perhaps to know, to give you an idea of not so much from a labor law perspective, but from a regulation in our system at municipality level, actually, where already in the beginning, when Uber started to work to expand its market in the Netherlands, quite soon there was a tribunal in The Hague that ruled that a certain specific the service of Uber was prohibited, and that was that you had just anyone actually can use private car to drive around people, and that is against our laws. And here, and that's really an exception, immediately fierce measures were taken. And the response of Uber was actually quite shocking in the Netherlands. So we're talking here about 2014, 2015. And the shockingness was that Uber did not accept actually the verdict, but said something like, well, this is only telling us how outdated your laws are. Your laws stem from the time that there were no smartphones, etc. So it's now up to the government to speed up modernizing the law. That was actually the message of Uber. But later on, they had to give in eventually regarding the specific Uber pop service. So people who not have any licenses to be like a taxi driver, but only private individuals. And 5 years on, this news message says Uber had to settle eventually the case and had to accept that this Uber pop service cannot be
Mijke, can I just ask you, this was true for many European countries, right? That the Uber pop service was not legal. I mean, a lot of countries did the same thing as the Netherlands, right?
That's true. Yeah, so I was just thinking that perhaps it's good to bring into remembrance, because it might be, but I'm curious actually to hear from you in the audience whether in America this is allowed. But indeed in most European countries this was immediately prohibited. Well, yeah, for the rest, you can say that the Netherlands was quite liberal at first instance. So it had the Dutch attitude was, we will wait and see how these platforms will expand their markets. It was seen as something exciting, something new. But what you see here on the slide are actually the biggest names of the platforms as we see them in the Dutch streets. So it's Helpling. It's not so much in the streets, but more in the houses. This is a platform, I don't know if you are familiar with it, but it's for domestic cleaning services mainly, and other small gigs helping out individual households. And then you have Deliveroo, that's quite known, I think, the meal delivery services. We have a special one, Thuisbezorgd. This is a Dutch-based firm. What is perhaps interesting to know is that they already from the start work on an employee basis. So they never labeled these platform workers as self-employed actually. And perhaps also interesting, Deliveroo started to work on an employee base, but then because it's tough competition, they made a transition to a self-employed model. And Uber, well, we already talked about that a bit, but their services which are based on specific licenses are accepted, and they are spreading actually quite fast across the Netherlands now. They're very much accepted. In general speaking terms, we often talk about taking an Uber instead of taking a taxi. Now, apart from this Thuisbezorgd, this Dutch company, which is built on employee design, the rest of these platforms that you see here have had court cases against them, and you see them here on the next slide. And you can also see then on the slide that the court cases are still quite from a quite recent date, actually. So it started with cases against Deliveroo. And what was interesting here, that the first Deliveroo 1 judgment was actually confirming the model of Deliveroo, as saying that it was this individual meal delivery rider who himself had accepted and even genuinely wanted this kind of self-employed contract. Deliveroo 2, on the other hand, which came half a year later, there the same court, so the District Court of Amsterdam, apparently took a more informed way of analyzing this model, and then they ruled that Deliveroo actually was based on misclassification, so that these riders should be seen as employees. Deliveroo did not accept that, so they appealed, and we have had actually much more recently, so I think February 21, we had the Court of Appeal judgment, and they say they confirmed actually the district court, so again confirmed that these workers should be seen as employees. Now there are big interests here, of course, at stake, because there are many meal delivery workers, and what is also then the case, that there might be a collective labor agreement applicable if eventually also the Supreme Court would confirm this, but Deliveroo went to the Supreme Court, so this case is still pending. And we are then also waiting with this saga. If that ends, then we would have a first judgment at the level of the Supreme Court. Regarding Uber, actually only quite recent, so half a year ago or so, we had the first judgment of the Amsterdam District Court, and for many reasons, perhaps also because of all the Deliveroo judgments already, it was quite clear case, according to the court, that this is typically an employer-employee relationship, because there are many differences between the platforms and whether or not they control the work, but the Uber example is seen actually also to a large extent also in the legal literature. There is here some kind of agreement, I must be a bit cautious, that Uber is such a controlling platform that it really tends to be an employer-employee relationship. And then we have help. I already said that this is about a platform mediating between supply and demand for domestic work, so cleaning services basically in individual households. We have a specific regulation in the Netherlands that makes it possible for individual households to hire cleaning services from a company. This is a bit difficult to explain, but it also has to do with fiscal measures, because it is of course difficult to treat individual households as real employers with all their responsibilities. And here the specific interesting thing is perhaps that Helpling was seen as a temporary work agency. So the contractual relationship between Helpling and the cleaners, so the ones who offer their services for cleaning on the platform, is seen as a temporary agency work contract, and that is seen as an employment relationship in the Netherlands, but a specific one, a kind of light touch as it regards the conditions that are applicable. So this is a bit the state of affair currently regarding the classification issue, which is one of the most important issues in the Netherlands right now concerning platform work, and that's quite logical if you see how our system works, because we have what we call a binary divide, meaning that you are either in or out the protection of employment law and labor law. And so we have quite a good protection, especially for workers on standard contracts, but also to quite some extent good protection for temporary agency workers, workers on fixed term contracts, and all kind of more atypical, we call that atypical workers. So there are only a few matters actually regarding specifically health and safety that where our statutes are expanded to solo self-employed. Solo self-employed, Roman also already used the term, is something which is quite prevalent actually in the Netherlands. In contrast to Germany and I think also Sweden, we have quite some solo self-employed. It tends to be around 10 or perhaps even 12% of our labor market currently. And it's also currently seen now as a big problem because of this huge size. And the current rather new government is seeing that this is a hot potato that should be that they should have some more restrictive regulation on that. Specifically, tax law should be stricter here, but it's very difficult because there are now so much vested interests and so much people who profit from this status of solo self-employed. Anyways, we have a system of social insurance, and that works a bit less black and white, you could say, because there we have so social insurance, social welfare is perhaps the terminology which is more common in the United States. We tend to call it social security, but we have two flavors actually. We have universal schemes. They are applicable to all persons legally in the Netherlands, so it's residence-based in essence. And this encompasses child benefits, survivorship benefits, basic pensions, and healthcare insurance. And so that means actually that also the platform workers are covered by these schemes. So they have a kind of minimum protection. So this softens, if you look from that perspective of social insurance, a bit this binary divide between being an employee or being a solo self-employed. And then we have employee-related schemes. Well, the word says it already. This is only applicable to employees. So basically, until the platform workers are reclassified, they are not covered by, not covered against risks of sickness, loss of income with sickness, disability, or unemployment. But they are, I'd like to emphasize perhaps as a important thing, they are covered by health insurance. That is not the problem. Now, what is a big problem in the Netherlands is our company pension system, because we used to say that we work 1 day a week for our pensions. So we're not talking about good protected employees. So 20% of labor costs for employers, in other words, goes to pension systems. This means that there are also already some cases pending regarding, so big pension funds are trying to get reclassification for some solo self-employed, including perhaps also some platform workers. But this is just to tell you how much labor costs are involved here. Then the collective bargaining as a last aspect of our system. So based on this binary divide, most platform works currently are out of the scope, because we only have these court cases I just showed you, but that's not the same as that from then on we have more or less a new paradigm, meaning that all these platforms workers would be seen as employees. No, not, I would say on the contrary, because it's case by case, and the platforms are then adjusting their systems a bit, so they are still trying to stay out of the realm of our labor law, including collective labor law. But what is perhaps interesting about our system is that in our Collective Labor Agreement Act of 1927, it's explicitly stipulated that collective labor agreements may also relate to contracts for specific work, so contracts not seen as an employment contract. And actually, this meant eventually, when we came under EU, when we were becoming member of the European Union, so much later, at the end of the last century, it showed that there was a clash actually with competition law, which is, as Petra said, EU harmonized legal area. And that led to a very important ruling of the Court of Justice of the EU, saying that collective labor agreements can include not only employees, but also what we call false self-employed, so bogus self-employed. This means actually that there is a little bit of room to expand the scope of collective agreements also to platform workers who would be seen as self-employed. But then it must be clear that they are false self-employed, and here you see the criteria. That means that workers should actually form an integral part of that employer's undertaking, so that they are, if you pierce the veil in a way, that you can say that they work much, that they have much more in common with an employee. And then we used to have very restrictive policy guidelines, but these were relaxed from 2019-2022 on. And here you see what it basically entails. Interestingly, apart from that, this scope that we have a little bit at least to cover false self-employed in collective agreements. So bargaining, trade unions can then bargain also tariffs for these self-employed workers. It's also the case, and this is explicitly told by the Dutch Competition Authority, that if there are arrangements made between two undertakings, so then we have to see the platform worker as an undertaking, that if these are about levels of payment which are basically on the subsistence level, which is also linked to our mandatory minimum wage law, then the Dutch Competition Authority will not impose fines on such arrangements, because they consider this then actually as not in breach of competition law. Why? Because they actually say, well, if we would say that this is unfair competition, it would mean that these kind of workers have to lower their rates perhaps under the basic minimum wage level, and they would then outcompete employees in the same branch, for instance. I hope it's a bit clear, and otherwise I'm happy to explain more, of course, later on. So here you find the summary. So regarding classification, which is very important for being in or out of labor law, there's much uncertainty still, but there is a trend.
We having a platform issue, or I think okay?
I just gained connection again. Sorry, I was somehow lost the connection. Perfect. Can you all hear me? Excellent. Thank you, Mijke, for that. And now that was extremely rich, and I think plenty to come back to. So thank you so much for this. And I think we'll just move on to our Swedish speaker now. Annamaria, are you there?
Yes, I'm here. Can you hear me?
Yes, let me introduce you quickly. So you are, of course, an assistant professor and a senior lecturer at Lund University. Associate professor, sorry. You have published on a lot of topics to do with labor law, such as, personal privacy in the workplace, drug testing, rehabilitation, collective bargaining for self-employed workers, and social and labor protection for workers outside the traditional employment relationship. So we're very honored to have you on. And we'd like to hear from you, of course, about the legal implications of the gig economy in Sweden and how the traditional system of collective bargaining in Sweden is impacted by these changes that the digital economy brings. So
Yes.
go ahead, please.
Yes. Thank you. Thank you for arranging this seminar and inviting me. I will just share my screen now.
Perfect.
Like this. So can you see it?
Absolutely.
And it's moving.
It is.
Yes, very good. Petra asked me just to give you a brief overview of the Swedish collective agreement system to start with, because the collective agreements in Sweden is the most important instrument for regulation, the labor market. As you can see, the coverage of collective agreements is 100% in the public sector. And in the private sector, the blue collar worker, the coverage is 96% collective agreement, and it's 75% among white collar workers. And this does not depend on the organization level of the unions, but it depends on the very well organized employers. Because when an employer is a part of the Swedish employers department, then he have a collective agreement, then he used the collective agreement on all his employees. And this make the Swedish employers organization real powerful actors in the Swedish labor market, together with the unions, of course. But the unions membership have declined a bit since year 2000 with 12% actually. In the private sector, with the unionization level is 57% among blue collars and 67 among white collars. And of course, we are a bit worried about this, because if the union and the members in the union will decrease even more, then the unions, together with the employers' organization, won't have the same position in the Swedish society. Because here, I worked in the Swedish employers department organization in the 80s and the 90s. And when you are a part of this, when you negotiate, you are even more powerful than the parliament in a way, because when the parliament even think about coming with a legislative initiative, the social parties immediately go to the negotiation table. This is a tradition. You can see this photo from the 1930s. And then the parties negotiate and they conclude a collective agreement. And then if you are lucky, then the parliament will take this collective agreement and make it the law. We have seen this 3 or 4 times the last 2 or 3 years. So I think that the social partners now, they are even more powerful in a way than they ever been before. So of course, you have to have this perspective when you talk about how to regulate the regulation for platform workers as well. And you can see the collective agreements, they covers everything. Because the statutory legislation in Sweden, they don't cover overtime compensation and social hours and a lot of other things. It's only the collective agreement that covers this and give the employees all those rights. And I think I will comment now the suggestion from the EU Commission, and it's 3 different parts. And I will start with the first one. So you will see this picture again. I will start with the proposal for directive on improving working condition in platform work and the classification. Just like Mijke told us, this is really important. And of course, in the suggestion, Article 4, there was they suggest a legal presumption for who's going to be an employee in the gig economy and the platform economy. And that's a very unusual construction, I think, out of a Swedish perspective, and I will show you this. I will come back to the other two. So I just say something about the Swedish situation at the moment, because Sweden, just like most of the other European countries, have a binary system. You are either in or out. If you're an employee, then you're in labor law and that part of Social Security. And if you're self-employed, then you're outside labor legislation, but you're in another part of the Social Security. And in Sweden, the platform work is defined by national legislation, and it depends whether it's going to be an employee or self-employed. Depends on mostly, I think, on the business model of the platform. But I think most of the platform workers in Sweden in labor law will be regarded as employees. But we have had just very recently 2 cases of from the Work Environment Act, and the appeal court decided that they are not employees, those platform workers. So the Work Environment Act is not applicable. And that was, of course, a different point of view if you compared what I think they would have been in the Employment Protection Act. And then we have something special in Sweden called umbrella companies, which the companies put in between the platform and the employee. But I think I will come back to them if you have any questions. I won't talk so much about them now. And what did the Swedes think about this platform directive? Well, both the parliament and the employers organization and the unions, they said absolutely no. Like it was the only one in Europe actually, because the legal presumption, it felt so very different from the overview that you used, the overall judgment that you used to do in Sweden. So they said that Article 4 and 5 was too detailed and not improper with the directive's goal and purpose. And the definition of a concept of employment must be completely national. So, and the legal presumption defined labor law will not only affect labor law, but it will also affect social security and tax law. And the parliament, they did not like the idea, because in labor law, we have one definition, but in social security, we have a definition depending on tax law and not on labor law. So a platform worker can very well be an employee in labor law, but in social security legislation, he will be self-employed, which means that different rule will apply to him. The second suggestion here came, and that was how to handle collective agreement for self-employed. And in this communication from the Commission, they said, among others, in section 33, that collective agreements aim to correct a clear imbalance to bargaining power to solo self-employed person relative to their counterparty are intended by the nature and the purpose to improve working conditions. The Commission will not intervene against them. And out of a Swedish perspective, I think that was will be very welcome, because we have solved the problem with self-employed in the 1950s. I think we have also for the Nordic country a unique construction. We decided that self-employed, who's essentially work at the same nature as an employee, they should be regarded as employees in the Co-Determination Act, which means that they have the right to organize, the right to negotiate, the right to strike, and the social partners conclude collective agreements for those self-employed dependent contractors, as they are called. And how do we handle with the competition legislation then, you can ask. And we solved that too. In section 2, of course, we made an explicit exception for agreements between employers and employees, which is very common, of course, in Europe. But then we decided that the concept of employee should be the same as this one. So it's a real wide concept of employee in our Competition Act. And this means that the dependent contractor, the self-employed, they are covered by the exemption in the Swedish competition law. So we don't have any problems at all, at least not until we come to Brussels and the European Court, because I think, as Mijke told us about the FNV Kunsten case, for most countries, this opened up the possibility to conclude collective agreements for false self-employed. But for a Swede, this is a real narrow, it's a narrow concept compared to our wide dependent contractors. So for us, the FNV Kunsten case maybe would cut out some of the self-employed for whom we can conclude collective agreements for the moment. So hopefully this, what the Commission said that they won't intervene, could be very welcome for us. For we can compare that the Danish, just a couple of kilometers from where I'm sitting here in Lund, they have concluded collective agreements for platform worker, and their competition authority immediately attacked the collective agreements as it was for self-employed, because they don't have this solution that we have in Sweden. So there we differ a bit from the other countries. And of course, then we have this third part of the proposal, and that is about access to social protection for workers and self-employed. And of course, the classification will be difficult. It will be very important here as well. And when I talk about social security now, I will focus on the health. I will focus on the health and sickness insurance, and the parental leave insurance, and the unemployment insurance. The right to medical care, it's out of it covers everyone in Sweden. That has nothing to do with if you work or not. But most, I think, when you, I got it's difficult to see because I can't just move this one. So security for economical dependent. We have in Sweden, we have a system that both employees and self-employed are covered by unemployment benefits, sickness and injury benefits, and parental allowance, and retirement and old age benefits. And they are all mandatory except unemployment insurance. The aim for the legislator is to construct a statutory regulation that give traditional employees and genuinely self-employed not exactly the same, but a very similar social protection out of those insurances. But of course, entrance to social security, to social insurance and calculation of the benefits differs. And generally, I think the entrance to the benefits for social security, it's more favorable for employees than it is for self-employed, but it's not meant to be like that. But sometimes it could be difficult to show how much you earn as a self-employed. And the social security fees, of course, you can wonder. We pay almost 32% of the paid gross salary. And that's the same amount for both self-employed and for employees. So it doesn't, you pay the same kind of a tax for both the self-employed and for employees. So it's not cheaper to have self-employed than it is to have an employee working for you. And out of this, I think the pension is a huge part. It's about 10% out of the 32%. And we also have a roof amount in what you can get. You can never get more than 380,000 crowns, which is 38,000 euro or something. That's a limit. It's the employer who pays the social fee for their employees, and self-employed, they pay this social security fee themselves. And the principal, he have to pay for the self-employed. Sometimes he have to pay for some self-employed too. And I think we can come back to how the financiation, mostly of those insurances and benefits, are financed by the employers over the taxes. We can come back to this. What problems can you see when you try to create parity between employees and self-employed, as we do in Sweden and the other Nordic countries? Well, the calculation of compensation could sometimes be difficult, especially for temporary employments, and they could be put in some disadvantages. Assignment workers, they are a problem because they are in a gray zone. They are not employees, and they don't have a company of their own company, and they can fall in between. And especially this construction with umbrella companies, which is kind of three-party relationship, have created problems for them, especially in the unemployment benefits. Neutrality among different forms of companies. If you have a closed company or a limited company, the aim is that it should be the same kind of benefits. And of course, we have unreported income in Sweden. The tax authority is very efficient, but still, especially among platform workers, it has been a problem with unreported income. And of course, they are not included in the calculation for benefits at all. But I think the tax authority, they work very hard with this to see so everything is on the text. Well, thank you.
Thank you, Annamaria. That is fascinating. And I think we all agree that it's, I guess it's because it's also a new phenomenon that it's complicated to see all the implications of all this. But I think probably our American audience has questions. I know that the first question has come in, which is about a question on whether there's been a case of an employer having to shift, being forced to shift from having contractors to actually calling them employees. I happen to know that in France, they have imposed some constraints to what platforms can do and what some rights that they have to give all their contractors. But is there a case, I guess this is, maybe I turn to you, Mijke, to begin with for my question, but all panelists are more than welcome to give a reply. But the court case is the one that's pending in the Netherlands, and also I think in Sweden we have a court case as well on the food delivery company. Are those and collective agreements, and also Roman mentioned organizing or some of these workers or contractors. So what do you see as, is there already a case in any of your countries where a company has had to shift, or do you see it happening perhaps in the future? Would you like to start, Mijke?
Yes, of course. And sorry for the interruption of my internet connection. But yes, so to answer your question, I answered in the chat that where really you can say Uber was forced to shift to an employee model, and they seem to have done that as far as I know, although half-heartedly, is in the UK, because there you had the first ruling, but also now the only, as far as I know, on Supreme Court level. On the other hand, you have indeed legislators who have been more active, and I think that's indeed the case in France, but a more recent and also more far-reaching legislation is in Spain, actually. In Spain, there is really a legislation now also partly based on court cases, I think, where the platforms are seen by legal presumption, at least, as employees. So it has been part of an example for this initiative on EU level. And they also they have some quite clear transparency rules in their legislation, meaning also that these platforms should show how the algorithmic model works, to a certain extent at least. So Spain can be seen as a forerunner in a way, if you compare that to the EU initiatives that also Annamaria gave an overview of.
Thank you. Any other panelists who would like to, and also Larry, maybe you had more than one question. Maybe you want to put your questions to the panel yourself.
Well, I can say we have so far not have any cases from the labor court about, I think we will have soon, but not yet from the labor court if platform workers are employees. But it's not unlikely that they are going to be judged as employees. We have these cases from the Work Environment Act where they were not employees, they were self-employed. So the Work Environment Act wasn't applicable. And then we have some cases from the administrative courts about social security, health, sickness benefits and unemployment benefits. And in those cases, I think the authority really tried to avoid false employees. So they have, most of those cases have the result been that the platform workers are not employees in the social security legislation, because those authorities, they are not they are afraid to pay unemployment benefits and social security health sickness benefits for those employees. They don't want to have platform workers as employees. So it's the opposite as it is.
It could actually be a basis for fraud, basically, where people get registered randomly as workers or contractors and they're in fact maybe not doing any work, and then they get the benefits.
Yes, that's what that's the problem.
That's the risk. Mm-hmm. That's the risk. Okay, thank you. Roman, do you have any comments on this?
I just thought about the gig economy in Germany, especially in the field of delivery, food delivery services. And some years ago, there were two great competitors. There was Lieferando on one side and Deliveroo on the other. And Deliveroo was their business model was dealing with self-employed persons, and Lieferando with employees. And Deliveroo, I think 2 years ago, they get away from Germany with their business model, and now Lieferando is kind of the big thing when it comes to delivering services. And I don't know what the background is. It is, of course, I would say that the companies need persons for delivering and to be attractive. That's one thing. And I think, of course, it's the pressure from the politics side, because some years ago they were shifting what we called Industry 4.0, shifting through, okay, we watch more and more on the influences of digitalization. And there was, I explained it in my presentation, there was, of course, a huge initiative from one union and to show all the working conditions in the platform industry, especially in the delivery services. So I would say it was both the business models changed a bit to be more attractive, and there was, of course, political pressure on the other side.
Thank you. Larry, would you like to comment or put further question on this topic since you started it? Maybe not.
Well, maybe I'll just add another question. Just
please do.
I follow gig employers in the U.S. pretty carefully, and employment in general. You know, and I and others have documented how poorly Uber drivers and other workers are paid, and also the tremendous turnover they have. So Uber, in order to just maintain drivers, has to hire a lot of people and to expand even more. It is curious to me, I just don't understand it, why even in an environment like in the United States now, I don't know the conditions in the European countries, 3.6% unemployment, people quitting jobs all the time. How do places like Uber still attract a lot of workers who end up earning the equivalent of minimum wage once you take driver expenses into account? So I know there's an attraction to flexibility, and many people do it for a very short period of time. But it's just something I'm thinking about. Is when other people are thinking about that.
Yeah, panel, who wants to start?
Yeah, perhaps Roman already gave part of the clue, I think, in the beginning of his presentation, and I think that's also true for the Netherlands, especially these Uber drivers, but we see it also with the meal delivery services. Many of them are labor migrants, and that is probably the explanation. They have a more vulnerable position in our countries. Sometimes it might be even fully informal, but even if they have a status or are from a EU country, for instance, where they have lower levels of pay, it is attractive for them to do this work. So I think, but it is very difficult to bring hard evidence because there is not really statistical evidence on this. And it's true indeed that it's very, very fluid. So people are on the platform and then they are out apparently. But if you also, some empirical findings seem to confirm that.
So Mijke, you're actually saying that they are already,
sorry.
a lot of them are people who were born outside of Western Europe, and they have migrated to these countries more or less recently, and they don't necessarily speak the language. They don't speak Dutch, German, Swedish, and so they also have trouble finding other jobs.
Yeah, and those who have, of course, because of language barriers, already a more difficult position to find out their rights, let alone claim them.
That's an important part of the puzzle. And there was a question, maybe Larry, you want to follow up, but there was also a question from, was it Steve? Who was it? About the Ukrainian refugee wave right now, and that they will be looking for short-term work. I know that it differs within Europe. Some countries allow people to work if they find work while they are applying, while they are in the application process, applying for asylum or for a residence permit. Others do not. So that's already one difference. But it's true also that our countries, especially Germany and Sweden, already took in a massive amount of Syrian refugees and also Afghans in the past 8-9 years. So this Ukrainian refugee wave is yet another one, but it comes on top of a lot of other refugee flows. So, but Annamaria, do you want to comment on the refugee question?
I think Ukrainian wasn't it a decision from the European Union that all the Ukrainian refugees should have the right to work for, is it 3 years or something?
Okay.
The permission to stay in the EU and then work for 3 years without any problems immediately when they arrive. I think that they're not. We don't have that many refugees from Ukraine so far. And it's very new, so I don't think they have time to start to work yet, but I'm sure that they will as soon as possible. Probably.
Do you think it will drive gig economy, Mijke, or any of you?
Well, it's mostly women and children coming now.
Yeah.
And they of course, the women, they will need daycare for the children before they can start to work. So I think it will take a time, and then they will start to work probably.
Purely based on anecdotal evidence, also from newspapers, etc. What is also interesting and might show actually also a good a good aspect of this remote working. You also see stories from people who have fled to the Netherlands, and they can keep working remotely for their Ukrainian employer, apparently. So in the safe part of Ukraine, for instance. of course. And apart from, so more directly to the question, there are already warnings against human trafficking. So it is indeed, we have to be careful, and it must be monitored carefully how this influx of Ukrainian women, indeed, mostly, and children, will hopefully not lead to very abusive situations on the labor market.
Thank you. So I would love to, we have 10 more minutes. I would love to end, let me just say now, to ask you what you believe the future will hold in terms of, we've talked about collective agreements, we've talked about court cases, we've talked about the attempts to regulate some standards on European level, but broadly, if you can all say something at the end about what you think will happen, if you're going to guess. But also we have before we do that, we have also a question here about public relations strategies that platform companies have used in the European Union. I think the question is, when it comes to opposing the classification of workers as employees. So really, if there's been a lot of aggressive PR work or campaigns from the platforms to kind of, get parliaments or unions or whatever to act in a certain way, or to scare them, or simply have an impact on the debate. I think that my own reflection, if I'm allowed to have one, is that in some countries, like in my own, in Sweden, the unions and the employees associations are very powerful. So a newcomer will be less powerful in terms of marketing. But so that kind of differs from the US perspective, where the corporate interests are usually quite strong and can have a lot of an impact towards Congress and so on. But what are your views on that? Roman, have you seen a lot of aggressive marketing from platforms? I think you mentioned some of it in your presentation, but do you have any examples or reflections on that? Thanks.
Can we skip? I just had my daughter was just there. Can we skip, and then I?
Yeah, you can come back. Anybody else like Mijke or Annamaria?
Yeah, I can see. Well, I gave the example from the beginning when Uber reacted very arrogantly to the first prohibitions of Uber Pop. But they have a very smart strategy, I think, regarding lobbying in our political landscape. They become members, or are members already, of influential political parties. We also have a former European commissioner who is in the board, I think, or has been in the board of Uber. So yes, there are clearly these kind of smart lobbying strategies. On the other hand, you see, and this you have now quite some resistance, more in general, against these platforms and these algorithms, also against Facebook. And for instance, a strategy of Facebook to have a large data center in the Netherlands. This was also very aggressively marketed in what we think is an American way. And that was not accepted. That was seen as too aggressive, and has helped to not get what Facebook wanted, actually. So it's not accepted so much anymore in the Netherlands, but it has been successful in the past. And the litigation strategy, I think, is clear. I think that these platforms do that everywhere. So they never will change really their models until they might be forced, and even then they will perhaps rather relocate than really accept their loss.
Interesting. Annamaria, any reflections on your part?
Well, if I should have a respect, how the working condition for platform worker will be solved in Sweden, I think it will be the ordinary way with collective agreements, probably, as we did with. I can compare with the temporary work agencies in the beginning of the 90s. It was completely new, and everyone was talking about it, and it was free, very strange.
You're talking about outsourcing work, yeah? That's what you're referring to. Yeah.
It took 10 years, and then the social partners concluded collective agreements. We gave them the same condition as the employees in the company. And I think if you give the social partners in Sweden, at least sometimes, I think they will solve the problem with platform workers as well. The problem at the moment is not who is the employee, but who is the employer. Because when the platform don't see themselves as employers, they are not interested to negotiate and conclude collective agreements. But if they are seen as employers, then I think they will solve they will conclude the collective agreements at the national level rather quickly.
And that is the court case that is pending now, correct? That is about who is the employer. That's what the question is.
Now, who's the employees actually, but the employer, if this directive will decide who's the employees, then the platform will be the employer. And then I think the union will start to negotiate with the employer organizations, and then we have a collective agreement at national level. Hopefully.
And then they will be considered employees.
Yes.
Will the platforms stay if that happens? I mean, do you see them maybe moving out?
I think so. Yes.
Okay.
Yeah.
Mijke, what do you think the future holds?
I think the future holds that these platforms eventually will be seen as employers. Well, not all, of course, but the main brands that we're talking about, so the Uber and Deliveroo. So these platforms that are really controlling the relationship and the payment, etc. And perhaps it comes at a time, because there you can see the parallel with these outsourcing temporary agencies in the past. It comes at a time when their markets are already so expanded that they indeed can afford then at a certain moment the employee model better than when it would have been necessary when they started with their market. But I'm not sure about that, of course. But there's a really strong trend now, well, telling us, I think, also at European level, that eventually they will be seen as employees. That's my guess, my best estimate.
Excellent. And anything else you want to add? Because we do have a few more minutes about the rest of the directive in terms of also the algorithms and transparency. Do you see that as significant? Do you see it as happening and maybe also leading to changes potentially on other markets, like in the US, if platforms have to start to be more transparent?
I think that is perhaps even a stronger, that it might be even something indeed which might be more influential, let's hope at least, because the transparency is also important for the platforms and where you can say that they might not be working on an employee model, because there is already a directive telling for small businesses that there must be more transparency. So to compensate the unequal bargaining power between a strong platform and the very small self-employed, for instance. Yeah, so and perhaps good to say as a last thing is that the Dutch position regarding the platform initiative, the legal presumption, the Dutch position is rather much in favor in contrast to the Swedish, because we have already a legal presumption model ourselves. And that might be a way forward, according to the Dutch political opinion.
And so you see this European directive as you think it will pass sometime soon, maybe with some adjustments, of course, because there will be negotiations within council, because governments have different, views. And
very difficult to predict. For instance, the Scandinavian countries always have a strong voice, and they are not so keen, at least Sweden. So I'm not sure. We also have a very interesting directive pending on minimum adequate wages, for instance. But we have already a directive on transparent and predictable working conditions. This will be enacted in August, and that will already give some small improvements also for platform work.
And what are they? Can you just say briefly what it implies, the one that will enter into force?
There must be some more information also for these workers where not it is clear whether they are self-employed or employees. For instance, and also regarding the small gigs, there are more. There should be more predictable working conditions. So, of course, and there's also a presumption. So there's also a part of a shift of a burden of proof. I'm now saying it in a very brief and very not specific way, but there are some small improvements that might, if they are used, lead to some changes here to the benefit of the workers involved.
Excellent. So it's all moving pretty fast. Thank you. And finally, Roman, we have 1 more minute. We talked about how platforms are platform companies are influencing the national debate. Do you have anything to say on that in Germany? Then also very briefly, what do you think the future holds in Germany for the gig economy?
I would agree. I would say that first of all, I hope that this regulation is coming because it's needed, of course, and I would say there is, of course, there would stay this broad heterogeneous business models where you have, of course, platforms with like freelancer platforms where the people are self-employed. But I would say that the pressure would rise, of course, and that the platforms would increase where we have to deal, where the people are employees, of course. What I think is really important is the transparency on the algorithmic management. That's, I would say, is really important because they are shaping the conditions of work, and especially for us as unions, it's important to understand this black box, how they are affecting the working conditions, and of course to have influence on the algorithmic management systems through collective agreements on the level of company. I think that's important to be more progressive and not just passive.
Interesting. So that's a key thing to watch as the European Commission is trying to influence member states and put pressure on the platforms to understand better what their business model is like and what the algorithms and the management, what it actually implies for the contractors, the workers. Okay, well, I think it's been a really fascinating discussion. I'd like to conclude here by thanking you all so much and hand it over to you, David, if you have any final words.
Thank you very much, Petra, for organizing this panel. It's been outstanding and very interesting, very serious issues that we have to address globally. I wanted to thank everyone once again and also mention that it will be May 18th that Anton Hajar of the U.S. Postal Service addresses the DC Lera panel. That's the next event. So I hope to hear from some of you in the future. Thank you very much for National Lera, for Emily and Bernadette in the background who were organizing everything. Any last thoughts from Emily?
I don't have anything to add other than our own virtual meeting is coming up June 2nd through 5th, 2022. We'll have like 85 different sessions happening over 4 days. It's an extravaganza of sessions. You are all invited, and it is virtual. So please visit our website, leraweb.org, and please sign up. Thank you.
Thank you very much for that notice. And thank you for Tequila for contributing and all the board. Have a good afternoon. See you someplace on Earth.